Please the court, Attorney Douglas Rand Peacock, for appearing for Grove and Centron, PA, on behalf of CQB 2010 LLC. Our appeal is really based on two issues, as a brief. One being the witness's testimony being based on at worst admitted assumptions, and at best documents that they reviewed but were not presented to the trial, and thus hearsay testimony on key issues. One being the payment history, obviously, where they admitted that the payment history they provided contained the prior servicer's payment history, which they said they had, but never moved to admit. And so the court's left having
But that payment history was incorporated into the current lender or the current servicer's payment history, correct?
So they testified.
Well, so what are we supposed to do? Ignore that? I mean, you say that like it's irrelevant, but she testified to that effect.
But I believe the best evidence rule would still require them to submit those original records.
Was there an objection based on the best evidence rule?
I believe there is not, Your Honor. I think there was just an objection based on the authenticity of the records and the records being based on an assumption themselves. Actually, Your Honor, there was an objection based on best evidence, or at least the position was brought before the court that the documents themselves were not best evidence of the overall damages assessed against the named plaintiff and defendant, and also by extension my client, who is now the owner of the property.
The witness testified that the prior lender's payment history had been reviewed as accurate before it was incorporated into the appellee's records. Is that correct?
Based on assumptions that it had been done, yes, Your Honor.
Have you any case law that says every payment history that precedes the current lenders has to be admitted into evidence in order to support the cause of action?
No, Your Honor, I don't have anything that specifically excludes prior, that requires the presentation of the servicers or prior servicers, but this court has made efforts to where plaintiffs, usually the issue has been where plaintiffs try to bring that in as the prior servicer's record as being part of theirs. I think here's a distinction, whereas the plaintiff came in saying, this is our records, and they started from a previous point, and there has been case law saying that where there's a number there, that's an assumption that that number is correct, you still have to bring in the prior servicer's records to at least establish what that number is based upon. It's basically an issue of the court was left to rely on the number being placed there at the beginning as being accurate, and it was brought to the court's attention and admitted that there are prior documents, which apparently by the testimony were sitting somewhere on the plaintiff's counsel's desk, which they chose not to submit. And that kind of brings an issue of, well, if they're there and they match, why don't you submit them too? How hard is that? And the plaintiff, even on rehabilitation, chose not to try and do that. The other issue that we talk about is the standing. And in this particular case, I will concede that yes, when the case was first filed, it was filed by SunTrust, but as alleged in the complaint, which I don't believe was amended, stating that SunTrust was simply the servicer authorized by Fannie Mae, who was in fact the owner of the note, which brings a real issue as to where is the original note, which the copy attached to the original complaint was not endorsed, but it was alleged that somebody else was the owner. The witness themselves acknowledged they had no idea if SunTrust had ever, or rather Fannie Mae had ever been the owner, had ever transferred the note back. And there was his testimony that the original note was with the plaintiff's counsel at the time of filing was also based on an assumption, not even acknowledging any notes or records or Bailey agreements that had been or could have been reviewed to base that testimony. So here we have an issue of outright standing, which this court even picked up recently with its Cedron versus U.S. Bank decision in June 19th, where having submitting a note later on that's endorsed in blank doesn't necessarily establish standing. And here the plaintiff still should be bound by their initial pleadings and have to produce some evidence that either supports them or amend their pleadings to state that they're just simply coming forward as the holder, and then they'd still have to establish that they were holder of a note endorsed in blank at the time of filing. That hasn't been established. They've substituted parties out, and there's only an assignment of the mortgage, so now we have an issue of, does PennyMac even have the authority to come into the case when the note's not, there's no evidence that it was endorsed in blank at the time of filing or any assignment of the note, which purportedly was given or owned by Fannie Mae. And so the point we're saying, Your Honor, is that this witness's testimony, the court improperly relied upon this witness's testimony, which was established to be both based on out-of-court documents, unspecified even out-of-court documents, and also outright assumptions. The witness didn't even acknowledge that he had looked at anything. He just assumed the plaintiff's counsel had it. He had no idea that the plaintiff had originally alleged that they weren't the owner. So his testimony conflicts with the records that were filed with the court, and for that matter, the record evidence presented to the court. And for that reason alone, we think the case, the court ruled an error to grant this judgment, and based on Cedron, they shouldn't get a second chance. The court should direct the trial court to reverse based on a lack of evidence to support both standing and damages. And with that, I'll reserve the balance of my time.
Very good. Thank you, counsel.
Good morning. Jacqueline Jones for the appellee. May it please the court. The first issue I'd like to discuss is the standard of review. The appellant said that the hearsay objection should be reviewed de novo. However, the case that he relied on, KV versus State, said itself the standard of review at trial court's decision on the admissibility of evidence is generally that of wide discretion given, and evidentiary rulings will not be disturbed unless a showing of abuse of discretion. The case went on to say that whether an excited utterance is under the hearsay exception is a abuse of discretion standard. Only if evidence is actually, whether or not it's hearsay, can be reviewed on a de novo standard. So we would ask the same as in the Bank of New York v. Callaway, where the 4th DCA reviewed it under abuse of discretion standard, and where the court weighs the evidence and is in the best position to make that decision whether or not it's properly before the court. We would ask the court to review it on that basis.
Let's assume that we're not gonna, and we're gonna review it on the de novo standard. Aren't you gonna win anyway? I mean, does it really matter that much to your argument?
No, I guess not, Your Honor.
I think it really did. I mean,
okay.
You clearly have a note that was assigned. You have a holder who brought the action, and you have testimony from a witness who said she was familiar with the documents, and accordingly. So I'm more interested in your view of this idea about the best evidence rule, about whether or not the evidence that was brought forward was in fact the best evidence, and whether or not that that rule causes you some problems.
Well, first of all, it doesn't, because the things that were in evidence were the original note, the copy of the mortgage, the assignments of mortgage, the payment histories of both PennyMac and SunTrust mortgage, and the testimony of the witness. So I don't really know what other evidence there can be put in. Appellant's counsel is saying that the records of SunTrust were not put in. However, on pages 24 to 25 of the transcript, he asked, "Are you submitting those on the record?" I said, "Yes, I'd like to offer these exhibits into the record," and handed the judge the SunTrust mortgage payment history that the witness had testified to. And she properly testified that they were checked for accuracy and checked to the borrower's credit history, and they were found to be accurate with no discrepancies. So I'm really not sure what else he would require, because under the WAMCO case in Callaway, we don't need the prior servicer's testimony. Therefore, correct evidence was before the court. I don't know what other best evidence there is. And the one case he uses is when a bookkeeper testifies to a company's records, and none of that evidence was before the court. So that just can't be applied to this case, Your Honors. And as to the holder argument, the original holder did file the original holder did file the complaint, and to ask the court to look at the owner question would go beyond what is necessary for the plaintiff to prove the appellant's counsel at trial had been asking several questions of the witness about who the owner is. However, that's really irrelevant when the original lender files the action, and there's enough proof before the court to find through the testimony, the assignments of mortgage, the payment history, that PennyMac is now the holder of that note. So it's unnecessary to look at the owner question, and that's similar to One West Bank v. Bauer. Thank you, Your Honors. If you have no further questions, I would ask you to affirm this ruling. Thank you.
Mr. Peacock?
Well, we did object, Your Honor, as to those records, primarily based on the authenticity, based on the witness's admission that there was assumptions that there was a review process that had been followed. There was assumptions as that even the prior server should have even followed industry standards. There was no actual documentation he'd reviewed to see whether or not there'd been any issues with those documents. So just to reserve, we did object on the issue of authenticity that was put forward by the plaintiff.
Thank you, counsel.
Thank you.
Both counsel, I just will take a moment to compliment both of you. We do not often do this, but the briefs were concise, to the point, and very helpful to the court. We talk about this, as do other appellate courts, on the seminar trail regularly, and we appreciate the fact that you highlighted the key issues, the key evidence, and got right to the heart of it. So well done.